Report the settlement, my lordship. Fourth or fifth.
When do you want?
Fourth or fifth, my lord.
Birth kodi yavat.
Reporting settlement.
Fresh matter, please give. Fresh matters that can wait till Monday, please give. And if I find there is no urgency, I'll adjourn it right away by 2 weeks. Even 100 memos you have given, I will not. Yes.
For settlements.
Wait. Yes.
For settlements.
Settlement kodi. Settlement della kodi.
For tomorrow, my lord.
No, tomorrow, sir. Give it. Yes.
Settlement, my lord. Yeah.
Settlement. Yeah. NDPS. Why tomorrow? Kodi. What is that?
It was last listed on 19th.
It will be next listed in January. Leave it. Yes.
Settlement, my lord.
No, sir.
This is for settlement.
What urgency, sir? Settlement kodi, sir.
Day after tomorrow, day.
Whenever you want, birth kodi.
Tomorrow, my lord. Day after.
When you want, please write and give.
Tomorrow.
That's all. Yes.
It was directed to list after serving of notice.
Let it come. It will come. Yes.
Is case of yes, yeah.
There are such.
That's all.
As far as the incident is concerned, just 2 submissions.
Earlier.
Filing in a memo.
Kodi. Yes. Next.
In the same manner, but I will not
No,
waste it
it's
all
all-
time. Now, my lord, coming to I would first address your lordships on the question of law, my lord, which I want to place before your lordships a slightly different perspective, so that, my lord, your lordships will define the contours of interference in a judicial review proceeding with respect to an action purportedly taken under Section 17A. Kindly now see Section 17A for a minute, my lord, in the perspective in which I want to place it before your lordship. I know it has been read to your lordships ad nauseum, but let me place it in the manner in which
Yes.
I would like your lordships to kindly read.
Yes.
No police officer shall conduct any inquiry or investigation into any offense alleged to have been committed by a public servant under this act, where the alleged offense is relatable. Your lordships may mark that word, my lord. There is something that turns on this word. Where the alleged offense is relatable to any recommendation made or decision taken by such public servant in the discharge of his official functions or duty without prior approval. So, my lord, this section does not contemplate even an application. Please contrast this with Section 19, my lord.
No, sanction operates on a different footing.
No, there, my lord, under 19, it contemplates a request.
Yes.
17A doesn't even contemplate a request.
It's all right. We'll see.
No, my lord, what was told to your lordship was that it is only the police officer who can go and seek
So
for...
that, if you see, that I straight away dispelled.
Yes.
For the reason that no police officer can begin investigation unless there is an approval. That doesn't mean police officer only should seek approval.
Exactly.
That I
And
already
in fact,
said.
my lord, the question of seeking approval itself is not contemplated under 17A. It is permissible that the authority acts on information which is available in public domain or otherwise without even a request being made. This becomes material, my lord, in the context of the serious submission that was made before your lordship, that a copy of the petition that had been submitted by respondent number 4 was not furnished to the petitioner, and that is a grave infringement of the mandatory requirement of 17A.
If the foundation itself does not require,
Exactly.
why would a superstructure require?
Exactly. My lord. That's what I wanted to point out, your
All
lordship.
right, next.
Therefore, that's first subject. Then, my lord, the second question would arise in the context of 17A. Should the recommendation be made or a decision to be taken by a public servant? It is to be relatable to.
No, in this case, relatable
Yes.
is quite debatable. We'll see.
Exactly,
Yes.
my lord. Relatable is debatable, my lord. I bow down. That is why an inquiry.
Yes.
My lord, if it was...
That is why an inquiry will see.
that's my submission, my lord.
Relatable is debatable.
Relatable is debate. That's right, my lord. I mean, at the stage of 17A, application of mind, there is no material which is available which can point in one or the other direction. It is a matter where suspicion, needle of suspicion,
No. Needle of suspicion pointing at a particular act of a particular person.
Quite right.
See, needle of suspicion also cannot be in thin air. So there should be something. And he has threadbare told what is there. We'll see whether it is relatable or not.
Quite right. Now, my lord, another important aspect that I want to bring to your lordship notice is relatable. No police officer shall conduct any inquiry or investigation into an offense alleged to have been committed by a public servant under this act. Now, what are the offenses under the provisions of the PCA Act? My lord, kindly see section 7. My lord, there's something that turns on section 7, my lord, which I want
Criminal
to point.
misconduct by a public servant.
No, my lord, there's
No, this
something
is,
more. There's something more. I want your lordship to be kind enough to see section 7.
Yes.
Any public servant who,
The offense relating to public servant.
yes, quite, no, my lord,
No, see, 7 is offense relating to public servant being bribed.
no, my lord, kindly see C.
The 7C is, 7C,
7C,
7C is the only thing that is something there.
exactly, my lord. 7C, your lordship will kindly see, performs and, no, my lord, more importantly is the explanation 1 and explanation 2 to section 7. Performs or induces another public servant to perform improperly or dishonestly a public duty or to forbear performance of such duty in anticipation of, in consequence of accepting an undue advantage from any person. Now, my lord, this is explained by explanation number 1. For the purpose of this section, the obtaining, accepting, or the attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by a public servant is not or has not been improper. So, my lord, I ask myself the question, suppose, my lord, in a given case, what has been done is legal. But that legal act has been induced by a public servant.
No, then it does not become an offense.
But then, my lord, I ask myself, what was explanation 1?
legal
Then
act-
kindly see explanation 1.
No, don't, not the self-golagman.
No, my lord, kindly, no, not in this case. Kindly see explanation 1. Otherwise, explanation 1 will have no meaning. Because for the purpose of this section, obtaining, accepting, or attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by a public servant is not or has not been improper. So let us assume, my lord, in a given case that it is not improper. I'm not in this case, my lord. I'm saying, look at the width of the inquiry that is required to be made under section 17A. It is for that purpose, my lord, that I'm pointing out this. In this case, my lord, I'm going to show to your lordships a few more facts.
2 more facts are there?
Yes, my lord. Yes. I'm going to show to your lordships a few.
More than what he has told.
Yes, my lord. Yes, my lord. There is something more. And on the same facts that my learned friend has placed before your lordships, my lord, I want your lordships to look at it in a manner in which I would like to place it for your lordships.
Different angle.
Different angle, my lord. Therefore, my lord, that would throw some light, would move assistance to your lordships
All right.
to see as to whether in this case there is something that requires to be investigated or the investigation to be scuttled without anything more. Because if the investigation is scuttled and the governor's order is set aside, there will be nothing more to be done in this case. Unless, my lord, it's a question of re-examination, rewriting that's a different matter. But
the submissions are otherwise. If you leave that also, everything subsists,
that's it.
is what he is.
I will, your lordships may look at that also. I'm not saying no. I'm not saying no, my lord. But there are different ways of looking at the same
That's
issue.
why yours is a different angle.
Exactly, my lord. That's why, my lord, when a lawyer, my lord, wanted an adjournment in court on the ground, my lord, that he had forgotten his spectacles. That said, not necessary. Take my spectacles. I'm not going to grant you an adjournment. And the lawyer, my lord, used the judge's spectacles and still said, I want your on an adjournment. He said, why? I'm looking at a case from your point of view. I want to look at it from my point of view. So, my lord, the way, my lord, one learned counsel looks at it, the way your lordship looks at it, the way I look at it are all different. Therefore, my lord, I want to place it from the point of view of how I would look at it. Now, my lord, I have to give a meaning to explanation 1. What is the purpose of saying even if the performance of a public duty by a public servant is not or has not been improper? Now, my lord, suppose, my lord, a legal thing is done in a given case, but it has been induced to be done by a public servant for the purpose of gaining an unfair advantage. Would that amount to an offense under the Act? My lord, explanation 1 seems to suggest that. Otherwise, my lord, these words shall itself constitute offense even if the performance of a public duty is not or has not been improper. Therefore, my lord, it appears as if the philosophy of the Prevention of Corruption Act is do not use your public office to obtain an advantage.
Legal or illegal?
Exactly. That seems to be the high pedestal of public morality, which, my lord, the Prevention of Corruption Act seeks to protect, my lord. Then, my lord, please look at explanation 2 in the same section, section 7. For the purposes of this section, the expressions obtains or accepts or attempts to obtain shall cover cases where a person being a public servant obtains or accepts or attempts to obtain any undue advantage for himself or for any other person by abusing his position as a public servant or by using his personal influence over another public servant or by any other corrupt or illegal means. So therefore, my lord, even if you have used your personal influence, not necessarily as the boss, not necessarily as the boss, even if you have used your personal influence, it comes within the mischief of section 7. My lord, in a given case, my lord, let's assume a public servant, a minister, my lord, is not in charge of the department. He has nothing, no role to play, but uses his personal influence. My lord, would it constitute a offense under section 7? Explanation 3, explanation 2 seems to suggest, yes, it is. The moment you hold a public office, it carries with it certain obligations and certain do's and don'ts, which are not attached to a non-public office. Therefore, my lord, even if you are not directly connected, but if you have used your personal influence over a particular matter in respect of which a decision has been taken and you are the beneficiary, that itself constitutes an offense under explanation 2 to section 7. Therefore, my lord, the contours of a offense in respect of which an inquiry is required to be held under section 17A are very wide. That's the point I'm trying to make for your lordship's consideration. Lord, it is not like a complaint which requires ingredients of the offense to be mentioned in the complaint, without which your lordships day in and day out interfere under 482 and quash it.
That's after registration of the crime.
My lord, it is after registration of the crime at the stage of investigation. Yes, but it could be, my lord, it never reached the court, excepting on FIR. Now, in a situation of that kind, even if there is, in the instant case, there are no allegations in the complaint, there's nothing. Still, if the sanctioning authority, in the instant case being the Honorable Governor, says, well, there is something that requires to be inquired into, not necessarily, my lord, as a list between A versus B, because the philosophy of 17A is different. The whole philosophy of the PCA Act is different. The philosophy, my lord, is to have a purity in public administration. That, my lord, is a paramount object of the Prevention of Corruption Act. If from that point of view, the sanctioning authority says, well, it is as important to be clean as it is to for the people to have confidence in a clean administration. Now, please look at it from that point of view, my lord. It's really not in the nature of a list between the petitioner and anybody else. It is in the interest of purity of public administration. If in that anxiety, if the sanctioning authority says, having regard to the high position that a person is holding, it is necessary that it should be inquired into, I ask myself, what is the scope of interference in a 226 judicial review proceedings? That, my lord, would be the approach I would suggest to your lordships to adopt in this case. It is really not a list between A versus B. there is an element of public interest, and if in that anxiety, the high functionary like the governor, and I will point out your lordship the judgment, my lord, which of course your lordships will be aware of it, that where a discretion is vested with a high functionary, the courts would be very reluctant to interfere with that order. My lord, your lordships are not going to look at, I would respectfully submit, with the order passed by the governor in under 17A, in the same manner in which your lordship will look at an order passed by the Tahsildar.
It was submitted.
My lord?
That was argued. I think.
Yes. So therefore, my lord, if it is so, and I'm going to show you some authorities on that. If that is the position, what is the extent to which this court can go into while examining the action of the governor acting under 17A being a constitutional functionary? So therefore, my lord, what I would submit to your lordship is, please look at it from the point of view, not as an adversarial litigation. When your lordships are looking at the sanction under 17A, do not look at it as an adversarial litigation. Please look at it from the point of view of ensuring not only there is purity in public administration, but that public confidence in administration is not sullied. If it is damaged, it is restored. What is the best way of restoring, my lord, an eroded public confidence in administration?
Where is it eroded?
Well, let me develop it, but I will show to your lordships that. What is the best? Because it is the very fact that a commission of inquiry has been constituted under the Commissions of Inquiry Act itself indicates that there is an anxiety to get this matter inquired into because it is a matter of public importance. And that has been referred to by the Honorable Governor in the order. If it was a matter in respect of which no inquiry was required to be done, I asked myself, why was the Commission of Inquiry required? Whole object of the Commission of Inquiry Act is that you will have this inquired into in accordance with the special statute in order, my lord, your lordship knows, my lord, that the report of the
So
Commission
you are
of
satisfied with the Commission of Inquiry?
No. I
What is your
tell you,
suggestion?
lordships, why? I tell you, lordships, why? Commission of Inquiry Act, unfortunately, my lord, a report of a Commission of Inquiry has no teeth.
We'll give it.
No, lord, yeah, but the statute doesn't, my lord. The statute doesn't, my lord. In fact, there was a recommendation made by the Supreme Court saying that something must be done, nothing has been done. And the Supreme Court, my lord, has recognized that all these commissions of inquiry report are put in cold storage.
We will not permit.
But that is an independent and a parallel remedy. That is not necessarily a bar to a sanction under 17A. Therefore, my lord, this submission I made is in answer to the aspect, my lord, of eroding public confidence in public administration. How is it eroded? The very fact that you constitute a commission of inquiry indicates that there is something to be inquired into. Is it something that does not require, is a matter of public importance, is what the Commission of Inquiry Act
Then there is
says?
something being inquired into.
Yes.
So
Yes.
Why all this exercise?
My lord.
Why all this exercise?
Of course, my lord, there are two parallel remedies. Of course, there are two parallel remedies.
Don't emphasize on what is being inquired into.
No, that is only to answer the question, my lord, as to where is the erosion of public confidence. If there was no fear of erosion of public confidence in public administration, then the question of constituting a commission of inquiry would not arise. It is from that point of view I'm making the submission that the very fact that the government itself considers that there should be an inquiry into this matter and a matter of public importance itself indicates there is something that required to be inquired into. And all that is required under Section 17A is that there is something to be inquired into. And the entire allegations, my lord, are with respect to persons holding public office. Maybe, my lord, ultimately after inquiry, there will be a clean sheet. Maybe not be, I don't know. But why scuttle it at this stage? I mean, why not? Whatever is the truth. Maybe, my lord, there is truth in what is being alleged. Maybe there is truth in what is being said for the other side. We don't know at this point of time. Therefore, at this point of time, would your lordships want the cloud on the purity of public administration to remain? is a question, my lord, I ask myself and pose it for your lordship's kind consideration. And I would say, my lord, that in matters of this kind, the courts must lean in favor of getting matters inquired. Not,
ನೀವು ಅಷ್ಟೊಂದು ಪಾಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅದು,
Courts. Which side? Lighter way, yes.
ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ,
In the lighter ways.
I know,
don't mind, yes.
no, I fully
Yes,
understand.
yes.
I fully understand, my lord. We have seen your lordships quite, and we have gauged, my lord, to the best of our ability
Yes.
as to what the court means when the court is asking a question. We know that. The one thing that we are never able to gauge, my lord, and rightly so, is what is the final decision.
Oh, if you gauge that, then what?
Exactly, we can't do that. ಅದು ಸ್ವಲ್ಪ ಕಷ್ಟ.
Yes.
ಅದು best is not to do it, my lord.
Yeah.
So now, my lord, coming back to the point, my respectful submission to your lordship is please lean in favor of getting matters inquired into. That consideration when your lordships are looking at 19 would be different, and we are not concerned with that
Operates on a
today.
different
In a
way.
different. Now, my lord, having told your lordship that, my lord, I prepared a list of dates and factual aspects, and I want to take your lordship through a few factual aspects, which is relevant.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ನಿಮ್ದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಪೂರ್ತಿ ಇಲ್ಲ. ಎಸ್.
Please note, my lord, just a few things, that between 1996 and 1999, I mean, this is not there in this. I would trouble your lordship to kindly just note these periods.
1990?
6 to 1999, the petitioner was the deputy chief minister.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ಅದು? ಇಲ್ಲ.
ಅದೊಂದು ಮಿಟ್ಟೋಗಿದೆ.
ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಬಿಟ್ಟು.
ಅದಕ್ಕೋಸ್ಕರ ಅದೇ you know written that, no? I'm sorry, my lord, I understand.
ಆಯ್ತು.
ಅದಕ್ಕೋಸ್ಕರ ಶುರು ಮಾಡಿದೆ, ಅದನ್ನ ಬಿಟ್ಟೋಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಶುರು ಮಾಡಿದೆ. 1996 to 1999,
ಹಾ.
my lord, the petitioner was deputy chief minister.
ಡೆಪ್ಟಿ ಚೀಫ್ ಮಿನಿಸ್ಟರ್.
2004 to 2000, I'm giving the dates which relevant. 2004 to 2005, he was again a deputy chief minister.
1 year.
Yes.
ಆಮೇಲೆ
The first stint as chief minister was, my lord, between 2013 to 2018.
18.
And thereafter, my lord, the second stint is from May 2023.
One moment.
We are concerned with the property, my lord, bearing number 46, survey number 464,
ಕೆಸರೆ
measuring
ಗ್ರಾಮ.
3 acres and 16 gundas.
ಕೆಸರೆ ಗ್ರಾಮ ಕಸ್ಬಾ.
Exactly, my lord, exactly.
Yes.
My lord, this property was originally owned by one Ninga.
Granted.
Yes, my lord, it was granted, and he was the owner. And he, my lord, had 3 sons, Mallaya, Mailaraya, and Devaraju. My lord, Mallaya and Devaraj relinquished their right in favor of Mailaraya. That your lordship gets it, my lord, at serial number 2 in the list of dates. Relinquishment deed by Mallaya and Devaraju over survey number 464 in favor of Mailaraya. Therefore, my lord, Devaraju had no right. It was, property was owned by Mailaraya. It is noted that Devaraju name is shown in the revenue entries after Ninga, and the name of Mailaraya is not depicted in the revenue entries. Then, my lord, I'm going to skip to a few things. Then your lordship may come to serial number 4. In 1991, Karnataka Urban Development Authority's incentive scheme for voluntary surrender of land rules 1991 came into force, while GO dated 29th of January 1994, retrospectively from the year 1991. According to the rules, a person is entitled to 4,800 square feet when the land is acquired between 3 acres to 4 acres. That is, my lord, they were entitled to, my lord, 2 sites. If the
Between 3
land
acres.
is in excess of 3 acres.
3 acres.
My lordship may look at the rules, my lord. Your lordship may look at the statement.
All
of
right.
this.
ನೀವು
I'm Filamet.
Yes.
Then, my lord, please look at serial number 6. My lord, I'm going to skip a few dates, my lord. May not be.
No,
It is given only for the
no, you
purpose of
can-
convenience. I'm
Narrate all the dates, no problem. But rules will go later.
very well, very well.
Yes.
Now, my lord, please look at serial number 6. Government of Karnataka acquisition of land for development of Devanuru third phase by Muda, 3 acres 16 guntas of survey number 464 was mentioned in notification. Notification reflected late Sri Ninga's name. My lord, we have the notification is available for your lordship's consideration. Now, my lord, kindly see interestingly what happens is serial number 8.
Hmm.
Devaraju sought for denotification of land.
Devaraja was not the owner.
No,
Mailaraya was the owner.
exactly.
Hmm.
Mailaraya was the owner because of the 1968 relinquishment
All
deed.
right, yes.
Devaraju sought for denotification of the land. Endorsement of Muda recommending denotification of land, that is on 30th of August 1997. And now, my lord, final notification issued on 20th of August 1997 where this property is acquired. It is at serial number 40.
It was not yet denotified.
No, it was, in fact, this is the final notification.
No. But what is this denotification?
The recommendation. He made an application, there was a recommendation.
Recommendation on 38/1997.
Yes, correct.
All right. But just before that, a final notification is issued.
Yes,
All right.
exactly. And the notification and that relevant property, my lord, is at serial number 40 of the notification. There are number of properties. My lord. Then, my lord, 30th of March 1998, an award is passed. And the amount, my lord, has already been deposited in the revenue treasury. It has been deposited. So with that, my lord, acquisition is over now. There is nothing more to be done. Then comes the notification, my lord, at serial number 11. 18/5/1998, where there is a denotification of the survey number 464. This is where, my lord, the problem starts.
This was the only land denotified or anything else?
My lord, I'll check, my lord. I'll check then till I answer your lordship's question. My lord, kindly, I tell you, lordship, my lord.
No problem. Later you can tell.
My lord, answer to your lordship question is only this land.
Only this land?
Yes. It is at page 109.
Nobody had applied for denotification?
No, my lord, I don't know whether anybody had applied, but the fact of the matter is that the denotification of 18/5/1998 is pertaining only to this land.
All right.
And we are given the reference number, my lord, as a statement of objections.
Huh.
Then, my lord, interestingly, on 25/8/2004, Devaraj, my lord, sold this property to B.M. Mallikarjun, my lord, who is the brother-in-law of the petitioner. And thereafter, there is a site inspection report. My lord, your lordship gets a site inspection report. Is it in your new list of dates, 5/3/25?
Is there?
My lord, there is
Yes.
one site inspection report
He has
of
taken this.
5th of March 2005. Your lordships have seen that, my lord.
2 inspections are done. DC says he himself has inspected
Yes,
it and
correct.
conversion is granted.
Correct. In that, I'm going to point out some very telling facts,
Huh.
which I'll come to. Shall I do it right now, my lord?
Yes, sir.
Please be kind enough to turn to page 125.
Of the objections,
Yes, my lord. My lord, page 125 is a communication from the Tahsildar to the Deputy Commissioner dated 5/3/2005.
Hmm.
Please be kind enough to turn to page 126.
Hmm.
And he says, my lord, he has done an inspection on 4/3 and the last paragraph at page 126. ಸ್ಥಳ ತನಿಖೆಯಂತೆ ಕಂಡಂತೆ ಹಾಗೂ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ ಒಟ್ಟು 3 ಎಕರೆ 32 ಎಕರೆ ಜಮೀನಿದ್ದು ಈ ಪೈಕಿ 16 ಗುಂಟೆ ಜಮೀನಿದ್ದು ಈ ಖರಾಬಿನಲ್ಲಿ 5 ಗುಂಟೆ ಆ ಖರಾಬಿದ್ದಕ್ಕೆ ನಿಯಮಾನುಸಾರ ಪರಿವರ್ತನಾ ಶುಲ್ಕ ವಿಧಿಸಿ ಉಳಿಕೆ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಮಂಜೂರು ಮಾಡಲು ವಿಶಿಷ್ಟ ಕಡತವನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. Now please look at the next one at page 127. This, my lord, is spot inspection. ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಕೋರಿ ಶ್ರೀ B.M. ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಬಿನ್ ಮರಿಲಿಂಗಯ್ಯ ಮೈಸೂರು ಇವರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯ ಬಗ್ಗೆ ತಾರೀಕು 17/6/2005 ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿರುತ್ತೇನೆ. ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಹಾಗೂ ಇತರೆ ಸಿಬ್ಬಂದಿ ಹಾಜರಿದ್ದರು. ಮೈಸೂರು ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ರವರ ಪತ್ರದ ಸೋ ಪ್ರಕಾರ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಅರ್ಜಿದಾರರಿಗೆ ಕ್ರಯದ ಮೂಲಕ ಬಂದಿದ್ದು ಖಾತೆಯಾಗಿ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿರುತ್ತಾರೆ. This is when acquisition is complete. The question of their being in possession would never arise. This is such a blatant.
No, but it was denotified.
Subsequently.
Huh?
Subsequently. The denotification was in
1998.
1998.
This
Yes.
spot inspection is 2005.
Correct. But it's already acquired. Where is the question of their putting in possession?
No, that is why I asked. Recommendation was made for denotification.
Correct.
Where is the order of denotification?
Nothing, excepting, my lord, what happened on 20th, when, my lord, there was on 18/5/1998.
No, that is an order.
Notification. Yeah, that's a notification.
Then it was denotified.
Yes, it was only on 18/5/1998.
It's all right.
Yes. Yes, my lord.
We don't have auto payment.
Huh?
We don't have the auto payment.
Yeah, this, if your lordship says, is there a order of no denotification, we don't have it. But
Notification.
notification is 18/5/1998. It is at page 109, which
All
when your lordship asked me, is this the only property which has been denotified? My answer to your lordship's question was, yes, that's the only property which has been denotified. Now, the first question that arises, my lord, is where is the question of this denotification? How can this denotification at all be done? Is it not glaring act of doing something which is not provided by the statute? When the property is vested, where is the question of a denotification? Now, in that context, my lord, if possession has been, if they say possession is with the Devaraju, I ask myself, how did possession go to him? Nothing that is available on record for your lordships to come to a conclusion this way or that. That is the reason why, my lord, it is only in areas where it is a gray area that inquiry is required. My lord, in fact, my lord, the very fact that so much of submissions had to be made to your lordships in order to point out whether there is, whether the needle of suspicion is to be pointed this way, that way, or none at all, itself indicate that something has required to be looked into. It is only that much that is required to be done today. If it was open, black or white, no inquiry is required. It is only in gray areas that inquiry is required. This is a case falling within gray area. Therefore, my lord, all that is required to be done is just inquire into it. I fail to understand, with due respects, why this case has been elevated to the level of taking your lordship's time over and over again for the simple purpose of simply an inquiry. In a situation of this kind, my lord, let us assume, my lord, the PCA Act was not there and a simple complaint had been filed, where there was no this filtration process, my lord. Let us assume it was not there. And I ask myself, if a complaint had been filed with the police authorities.
ಅದಕ್ಕೆ filter ಬಂದಿರೋದು.
ಇಲ್ಲ, ಬಂದೆ. And it had come to your lordships under 482. I ask myself the question, would your lordship interfere? I would say no. Your lordship would say, look, in the complaint there are some allegations. Let it be inquired into. I ask myself, why is it that that same test should not be done for the purpose of 17 years? 19 is a totally different kettle of fish. It's totally different. 17 years, is this a case where your lordships will interfere? I ask myself under 482 if a private complaint had been filed in the absence of PCA. Obviously, you all say, look, allegations are there. There are gray areas which requires to be examined. Let it be examined. What's going to happen to you? Nothing. I think, my lord, that is the way. I'm not oversimplifying it.
Just simplifying.
I'm not even simplifying it. I'm only saying, my lord, that's a legal position. And I think, my lord, we have complicated the issue more than what the issue warrants. It requires to be seen in this way. And if that is done, several objectives would be satisfied. One of them is this a complaint which does not warrant any investigation? If it is in the white area, your lordship will say yes. It doesn't warrant any investigation. That's the object of a filtration process. But this case, my lord, is in the gray. I mean, it's all right to say one way or the other, but we are at the stage of inquiry. Now, my lord, please look at the other dates. Your lordship will kindly look at.
No, you said there is a needle of suspicion.
Yes.
Is it a needle in a haystack or what?
I would not say it's in a haystack because, my lord, needle in a haystack is possibly something so trivial. We use that expression, my lord, normally to convey a very trivial, a very small thing, a very something so insignificant.
It's not that.
This is not that. Because it concerns purity of public administration. I can understand, my lord, normally this expression pin in a haystack is only to convey something very trivial.
That's why I said, what kind of needle?
But we don't know. It requires to be examined. The very fact that there is an allegation that has been made of this magnitude, and prima facie here is Devraj, who was not the owner of the property. He makes the application. At his instance, all this is being done. And he conveys the property in favor of the petitioner's brother-in-law, who gives it to his sister. And in a situation where sites have already been formed, now please look at that, my lord. Please look at now that area. Your lordship may kindly now go to seal number 15. 13, no?
Serial number?
My lord, kindly see, my lord, seal number 12. My lord, in 2003, despite survey number 464 is denotified, Muda forms layout, parks and roads. Sites are allotted by Muda to various persons. Now, my lord, then comes Devraju, who says, I am the owner of the property. You have sold my land. He sells the property in favor of the petitioner's brother-in-law. And then, my lord, there is an order of conversion, and then, my lord, there is a gift in favor of his sister. It is on the basis of these documents that the sister now says, please give me compensation / alternate sites. Now, please look at that. Please look at the item number 16. 23/6/2014. Representations made by Parvati for compensatory sites. This is the representation she gives. Now, if an ordinary citizen had made an application like this, I ask myself,
No ordinary person made? No, along with this, there are other applications.
we have
No
nothing
other
on record,
application.
Nothing on record. Nothing on record. We don't have anything on record. Nothing on record.
Then
Nothing on record.
why sites are distributed to everybody?
No. That is the sites which were distributed on somebody else's property to various persons. I'm talking about whether the real owner of a property which had been used by a public authority without going through the process of acquisition.
Right.
No such instance. This is the only instance.
Right.
Now, my lord, please look at, if an ordinary person had made an application like this, what would have been the attitude or the approach of the authority? Look, tell me who you are. What is your source of title? Please prove your title before I can even look at your representation.
And a mandamus before this court.
If that's not done, a mandamus by your lordships.
Direction to consider.
Exactly. Exactly, my lord. Your lordships are right. Consider we have hundreds and thousands of cases where representations are made, not considered. Your lordships issues mandamus saying do it within 3 months, 4 months. No, all this is not necessary in this case, my lord. It's not necessary for obvious reasons. The reasons are not far to see. That is what is required to be examined. What would the authority do if there was a representation by an ordinary citizen with respect to this, assuming that they're taking action, not sitting over it? They would say, look, there is a communication sent by one Parvati. Now, who are you? We don't have your name at all on record. We don't know who you are. Please prove your title. No such exercise. Nothing done. Straight away, now please look at, then the rules are amended, make it 50-50. As of 11/2/2015, it is on the basis of this rule of 2015 that 50-50 compensation is given. My lord, I have two as
50-50
that is,
compensation.
my lord, 50% of the extent of land which has been unlawfully
So
occupied.
3.16 acres andre about
Yes. About
half of that.
half of that. That's the formula. That's the formula in this new amended rule.
Hmm.
Now, my lord, if a property has been acquired and the compensation has all been deposited, the question of even granting one side does not rise. Property has become the property vested in the government. Where is the question of denotification? Now let us keep that aside for a moment. With respect to which rule will you take a decision on the representation that has been made, my lord, on 23/6/2014? It obviously must be with respect to the rule that existed at the time when the allotments were made.
60-40.
Exactly.
Hmm.
My lord, your lordship may kindly see when the allotments were made to various persons, my lord.
2004.
2004. I asked myself, how do you apply 2015 and give 50-50? If the encroachment or the illegal occupation was at that point of time, which is the rule which you will apply for the purpose of determining whether a person is entitled to, and if so, how much? By way of a
Are you accepting 60-40 entitlement?
assuming, without considering, I'm first submission is that not entitled to anything. No, of course not, my lord. Even 60-40, even two sides is not there. The question of my accepting, my lord, not accepting is not the real issue.
No. By submissions, I'm asking.
No, my lord, I don't. Of course not. I am saying that nothing was to be done. But in this case, look at this way in which it has been done. How do you give this 50-50 on the basis of 50-50, which was a 2015 rule, in respect of what is a wrong utilization of the property in 1998? I asked myself, how can it be done that way, my lord? Which is the provision under which they can give this 50-50 rule and give these 14 sites? There is none. It's a submission I would make for your lordship consideration. Because your lordship will kindly see, my lord, that all these sites were allotted. When?
19 allottees in the year 2004.
19 allottees in the year 1900?
2004.
2004, my lord. Yes, your lordship gets it.
2004 alla?
2004. 2003, my lord. 2003.
3 or 4 are.
3 na 4? Oh.
That's why I said he has threadbare covered everything.
Now we have produced one document. Give me page 111.
2009, my lord,
Give me
came
111.
to be allotted.
On continuous process.
My lord, we have produced.
No,
a
it started at 3, sir, then ended at 9.
Continuous process.
document. In a, all, I can. All right. Now, how does 2015 amendment apply? How did you apply this 50-50 rule? Well, everything can be overlooked for obvious reasons. You did not find out as to what is the title of Parvati. You did not go into the question as to whether there can be a denotification when the property is already vested. You did not go into the question of how many sites to be given, whether you will apply the 50-50 rule, 60-40 rule, 2 sites, nothing. How many times do you overlook? And my lord, your lordships have said it a number of times that where repeated mistakes are made, it leads to a conclusion of malafide. My lord, one order which is wrong, my lord, we don't allege malafide, and even if you allege, your lordships will not accept. But if even with respect to a court, your lordships have taken the view that if repeated orders are made in the same case which is wrong, then there is a ground for malafide. Now, how many times are the mistakes being made? Now, your lordship may kindly look at the next aspect as to what happens, my lord. Please look at serial number 19.
Number 18, so.
My lord, kindly see, now serial number 18 is very important. My lord, in December of 2017, resolutions are passed when the petitioner was the chief minister. What was told to your lordship was, well, it was in 2023. Where is the question? I was not there. That's not the date with reference to which your lordships will reckon this case. The date relevant for the purpose of the present submission would be December of 2017. Your lordship may let's look at that resolution for a minute at page 151 of the writ petition.
Of the writ petition?
Yes, my lord. Yes. My lord, in this, please be kind enough to turn to page 152, serial number 30.
Serial number?
30, my lord. ಅದು ಪೇಜ್ 152 ಲಿ 30 ಅಂತ ಇದೆ. 30.
52 ಚಾರ್ಟ್ ಏನಿಲ್ಲ,
152.
ಈ ತರ ಇದೆ.
ಅದಲ್ಲೇ 30 ಅಂತ ಅದೇ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಅಂತ. 30.
ಹಾ.
ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಸರ್ಕಾರವು ಕೈಬಿಟ್ಟಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಈ ಜಮೀನಿಗೆ ಬದಲಿ ಜನರು ಕೇಳಿರೋ ವಿಚಾರ. Then, my lord, please be kind enough to turn to page 153, second paragraph. ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಸರ್ಕಾರವು ಭೂಸ್ವಾಧೀನ ನಡುವಳಿಯಿಂದ ಕೈಬಿಡಲಾಗಿದ್ದರೂ ಕೂಡ ಈ ಜಮೀನನ್ನು ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿರುವ ಸಮಯದಲ್ಲಿ ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಸಹ ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿಕೊಂಡ ಉದ್ಯಾನವನ, ರಸ್ತೆ ಹಾಗೂ ನಿವೇಶನಗಳನ್ನು ರಚಿಸಿ ಫಲಾನುಭವಿಗಳಿಗೆ ನಿವೇಶನವನ್ನು ವಿತರಣೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಬಡಾವಣೆ ನಕ್ಷೆ ಪ್ರತಿ ಅನುಬಂಧ 3 ಮತ್ತು ನಿವೇಶ ಆಕಾಂಕ್ಷೆ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡಲಾಗುವ ಮಾಹಿತಿ ಅನುಬಂಧ 4. BM ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಇವರಿಂದ ಪರಿವರ್ತನೆಯಾದ 3 ಎಕರೆ 14 ಎಕರೆ ಜಮೀನನ್ನು ಖರೀದಿಸಿರುವ ಶ್ರೀಮತಿ ಪಾರ್ವತಿ ವಿಜಯನಗರ ಬೆಂಗಳೂರು ಇವರು ದಿನಾಂಕ 23/3/2014
ಖರೀದಿಸುವ ಯಾವುದು?
ಅಲ್ಲ, ಖರೀದಿಸಿಲ್ಲ, ನಾ ಇರೋದು ಗೊತ್ತಾಯ್ತು, ಅದು ಗಿಫ್ಟ್, ಅದು ಗಿಫ್ಟ್, ಅದು ಇವ್ರು ಬರ್ದಿದ್ದಾರೆ. ಜಮೀನನ್ನು ಖರೀದಿಸಿರುವ
ಪರಿವರ್ತನೆಯಾದ 3 ಸೋನ್ಸು
ಜಮೀನು
ಖರೀದಿಸಿರುವ
ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅವರು. ದಟ್ ಪಾಸಿಬಲಿ ದಿಸ್ ಖರೀದಿಸಿರುವ refers to ಮಲ್ಲಿಕಾರ್ಜುನ್ ಸ್ವಾಮಿ. That is to be charitable to the drafter of this resolution.
All right.
BM ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಇವರಿಂದ ಪರಿವರ್ತನೆ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ಖರೀದಿಸಿರುವ ಶ್ರೀಮತಿ ಪಾರ್ವತಿ.
ಖರೀದಿಸಿರುವ ಶ್ರೀಮತಿ ಪಾರ್ವತಿ.
That is how it is, my lord.
All right, no problem. Yes.
ವಿಜಯನಗರ ವಾಸಿ ಬೆಂಗಳೂರು ಇವರು ದಿನಾಂಕ 23/3/2000 ಮನವಿ ಸಲ್ಲಿಸಿ ತಮಗೆ ಸೇರಿದ ಜಮೀನಿನಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಈಗಾಗಲೇ ಬಡಾವಣೆ ರಚಿಸಿ ನಿವೇಶನಗಳನ್ನು ಹಂಚಲಾಗಿದೆ ಹಾಗೂ ಉದ್ಯಾನವನ ಮತ್ತು ರಸ್ತೆಯನ್ನು ನಿರ್ಮಿಸುವುದರಿಂದ ನಮ್ಮ ಜಮೀನಿಗೆ ಬದಲಿಗೆ ಅಷ್ಟೇ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರ ಸಮಾನಾಂತರದ ಬಡಾವಣೆಯಲ್ಲಿ ನೀಡಿರುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರ ಶ್ರೀಮತಿ ಪಾರ್ವತಮ್ಮ ಇವರಿಗೆ ಮಾರುಕಟ್ಟೆ ದಂಡವು ಜಮೀನಿನ ಪರಿಹಾರ ನೀಡುವುದಾಗಿಯೋ ಅಥವಾ 40-60 ಅನುಪಾತದಲ್ಲಿ ನಿವೇಶನ ನೀಡುವುದಾಗಿ ತಿಳಿಸಲಾಗಿತ್ತು. ಆದರೆ ಪ್ರಾಧಿಕಾರದ ಈ ಸಲಹೆಗೆ ಅವರು ಒಪ್ಪಿಗೆ ನೀಡಿದ್ದೇ ಇದ್ದು ಬದಲಿ ಜಮೀನು ನೀಡುವಂತೆ ಒತ್ತಾಯಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಾಧಿಕಾರವು ದೇವನೂರು 3ನೇ ಹಂತ ಬಡಾವಣೆ ನಿರ್ಮಿಸುವ ಸಮಯದಲ್ಲಿ ಸರ್ಕಾರ ಕೈಬಿಟ್ಟಿರುವ ಕೆಸರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ 3 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರವು ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿಕೊಂಡಿರುವುದರಿಂದ ಭೂಮಾಲೀಕರ ಕೋರಿಕೆಯನ್ನು ಪರಿಗಣಿಸುವ ವಿಚಾರದಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳುವ ಸಂಬಂಧ ವಿಷಯವನ್ನು ಸಭೆಗೆ ಮಂಡಿಸಲಾಗಿತ್ತು. Now, my lord, please be kind enough to turn to page 152. 153, I'm sorry. 154. 154, my lord, on top.
I'm there. Yes.
Top of the page.
I'm there.
Yes. ದಿನಾಂಕ 10/11/2002 ನಡೆದ ಸಭೆಯಲ್ಲಿ ವಿಸ್ತೃತ ಚರ್ಚೆ ನಡೆದು ಸಂಪೂರ್ಣ ಮಾಹಿತಿಯೊಂದಿಗೆ ಮುಂದಿನ ಸಭೆಗೆ ಮಂಡಿಸಲು ತಿಳಿಸಿದ ವಿಷಯವನ್ನು ಮುಂದೂಡಲಾಗಿದೆ. ಮಾನ್ಯ ಪ್ರಾಧಿಕಾರ ಸಭೆಯ ತೀರ್ಮಾನದ ಪ್ರಕಾರ ಪ್ರಕರಣದಲ್ಲಿ ಸಮಗ್ರವಾಗಿ ಸ್ಥಳ ತನಿಖೆಯೊಂದಿಗೆ ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಕಂಡ ಮಾಹಿತಿಯನ್ನು ಸಭೆಯ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. And then, my lord, there are all these sites which are identified. And now please be kind enough to turn to the next page. At page 155. ಮೇಲಿನ ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಹಲವು ಪೂರ್ಣ ನಿವೇಶನಗಳು ಹಾಗೂ ಹಲವು ಭಾಗಶಃ ನಿವೇಶನಗಳು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ಗೆ ಸೇರಿರುತ್ತದೆ. ಮೇಲ್ಕಂಡ ಪ್ರಕಾರ ರಚಿಸಿರುವ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡಿದ್ದು ಈವರೆಗೂ 15 ಪ್ರಕರಣಗಳಲ್ಲಿ ಕ್ರಯಪತ್ರ ನೀಡಲಾಗಿದೆ. ದಟ್ ಈಸ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದೋಸ್ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ದೋಸ್ ಸೈಟ್ಸ್. ಅದಲ್ಲದೆ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466 ರಸ್ತೆ ಉದ್ಯಾನ ರಚಿಸಿದ್ದು ಸದರಿ ವಿಸ್ತೃತ ವಿವರಗಳು ಈ ಕೆಳಕಂಡೇ ಇರುತ್ತದೆ. Now my lord, kindly see my lord, 6255 square meters is the sites, and 13, and then my lord, the road and the garden and the parks ಒಟ್ಟಾರೆ 13,759 ಚದುರ್ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣದ ಪ್ರದೇಶವನ್ನು ಉಪಯೋಗಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಆದುದರಿಂದ ಪ್ರಾಧಿಕಾರವು ದೇವನೂರು 3ನೇ ಹಂತದ ಬಡಾವಣೆ ನಿರ್ಮಿಸುವ ಸಮಯದಲ್ಲಿ ಸರ್ಕಾರ ಕೈಬಿಟ್ಟಿರುವ ಕೆಸರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ 3 ಎಕರೆ 16 ಎಕರೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರ ಉಪಯೋಗಿಸಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿ ಸಾರ್ವಜನಿಕ ಉಪಯೋಗಕ್ಕೆ ನೀಡುವುದರಿಂದ ಭೂಮಾಲೀಕರ ಕೋರಿಕೆಯನ್ನು ಪರಿಗಣಿಸುವ ವಿಚಾರದಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳುವ ಸಂಬಂಧ ವಿಷಯವನ್ನು ಸಭೆಗೆ ಮಂಡಿಸಲಾಗಿದೆ. ನಿರ್ಣಯ: ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಕೈಬಿಡಲಾಗಿದ್ದರೂ ಪ್ರಾಧಿಕಾರದ ವತಿಯಿಂದ ಅಭಿವೃದ್ಧಿಪಡಿಸಿ ಉಪಯೋಗಿಸಿಕೊಂಡಿದ್ದು ಪ್ರಾಧಿಕಾರದಿಂದ ತಪ್ಪಾಗಿರುವುದರಿಂದ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ 3 ಎಕರೆ 16 ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರ ಉಪಯೋಗಿಸಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿ ನಿವೇಶನ, ಉದ್ಯಾನವನ, ರಸ್ತೆಗಳನ್ನು ಸಾರ್ವಜನಿಕ ಉಪಯೋಗಕ್ಕಾಗಿ ಮೇಲ್ಕಂಡೆ ನೀಡಿರುವುದರಿಂದ ಪ್ರಾಧಿಕಾರ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದು ಅಭಿವೃದ್ಧಿ ಪಡಿಸದೇ ಇರುವ ಜಮೀನನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ಬದಲಿಯಾಗಿ ನೀಡುವುದು ಎಂದು ತೀರ್ಮಾನವಾಯಿತು. Now my lord, this next, your lordship may kindly go to page 157. ಸದರಿ 3 ಎಕರೆ 14 ಎಕರೆ ಜಮೀನನ್ನು ಶ್ರೀ
I've seen and marked already.
your lordship.
Yes.
Now my lord, the point I want to make to your lordship is this. Kindly see the amount of compensation with respect to this 3 acres 16 guntas which is assessed and deposited. It is about 3,24,000 rupees. Are you giving property worth 3,24,000 rupees? No application of mind on this. Well, you yourself said the property is worth 3,24,000 rupees. And what is the value at which these 14 sites that are given? No application of mind by the authority, my lord. You will exchange cheese for chalk. Is that what is being done? That's what has been done. That's the allegation. Should that not be inquired?
Is it the other way around?
No, I'm saying the 3 acres 16 guntas of 3,24,000, that is chalk, and what you have given is cheese.
Yes.
So, my lord, you get cheese for chalk.
Chalk and cheese. Yes.
I'm now putting it the other way. Yes, my lord. That's what has happened in this case. You have given them a valuable property in exchange for a property which was very much less in value than the property which you are given. My lord, may be right, may be wrong. But
Inquiry.
my lord,
It should be inquired.
into. That's the point, my lord. Every time we are told the same thing. And then, my lord, we are told that Brutus is an honorable man.
Yes, he is an honorable man.
Yes. That is what Mark Antony said, my lord, in
Antony
the
said.
funeral oration of Julius Caesar.
Yes.
Brutus is an honorable man. Well, let it be inquired into, my lord.
Carrying the body of Caesar.
Yes, my lord. Exactly. Exactly. No, my lord, I'm only replying to the last aspect of the third silo of my learned friend's argument. Now, my lord, your lordship may kindly go to the list of dates.
So
Moving
you're,
on.
you're
Your lordship,
carrying that statement further.
my lord.
You're carrying that statement further of Brutus. Not that he loved Caesar less, but he loved Rome
Hey,
more.
Rome more.
Yes.
Well, exactly. Not that we learned,
Yes.
Brutus said that, my lord, but kindly see, 18, my lord, your lordship now saw the resolutions. One aspect that I want your lordship to kindly note is no application of mind with respect to the value of the property, which I think, my lord, is a very important aspect when it comes to doling out public property. That I thought, my lord, was a very important aspect which the authority ought to have applied its mind. I am not asking your lordship to go into the question as to whether this is right or wrong, because that's not the subject matter of this writ petition. The question is whether undue favor shown by overlooking all these aspects, property already vested, no question of denotification, not entitled to even one side. In spite of it, you give them 50-50 on the basis of a notification of 2015. And then, my lord, the value of the property completely ignored. How many more issues do we want for the purpose of inquiry is what I ask. And now, my lord, please be kind enough to look at the next item, my lord, seal number 19 in the list. This is where, my lord, your lordships ask a pointed question always. What is the connection between the petitioner and all this? My lord, all this happens when the petitioner is in office, because he was the chief minister. Yes, of course, 2014-17 resolution was when he was the chief minister.
You said item number 19.
No, my lord, 18.
18.
18, all this happens.
18 years he was chief
He
minister.
was chief minister.
Not in 19.
No. I'm not saying, my lord, 2013, 2018. I'm talking about
In
2017.
Serial number 19.
Serial number 18. I'm
18.
sorry. I possibly was.
That's
I'm talking about serial number 18,
All right.
not 2018.
Yes.
Serial number 18 is in 2017.
Yes.
And it's such a sweet resolution. And everything, yes, we made a mistake. We have done this. We asked her. She said, no. What can we do? We have to concede to what she's saying. But how much more bending backwards do you want? Is what I ask myself. I have never come across, my lord, of authority bending backwards like this. Everything, everything is to be done to suit the requirement of the applicant. And now, my lord, please be kind enough to turn to the next one. Seal number 19. Letter of Muda to Principal Secretary seeking clarification. However, no clarification was elicited by any officers. Despite the same, Muda went ahead. Then, my lord, 2510, petitioner requested for compensatory sites once again.
Petitioner requested.
No, I mean, petitioner means the mistake. My lord. I agree. It should have been. I apologize.
If this was there, no argument was necessary.
ಇಲ್ಲ ಆವಾಗಲೇ ಹೇಳ್ತಾರೆ
Nobody's argument was
ಇಲ್ಲ
necessary.
ಆವಾಗಲೇ ಹೇಳ್ತಾರೆ ನಾವು 2021 ನಾವು ಇರ್ಲಿಲ್ಲ ಅಂತಾರೆ ನಾವ್ ಇರ್ಲಿಲ್ಲ ಅಂತಾರೆ 2021 ನಾವ್ ಇರ್ಲಿಲ್ಲ ಅಂತಾರೆ
ಇಲ್ಲ, ಆಯ್ತು, ರಿಕ್ವೆಸ್ಟ್
he was the leader. No, man, it's a mistake. It's okay.
Yes.
Yeah, please.
So it is not the petitioner.
No, it's the petitioner's wife. Yes. It is a mistake.
Yes.
Now, my lord, between 17 and 21, nothing is done. Clarification also not received from the principal secretary of the government. What do we do about this? Well, what would be the natural course to await? No, it doesn't happen that way. Now, my lord, please see the order dated 30th of December 2021 issued by Muda allotting 38,284 square feet to the petitioner's wife. That is the one, my lord, document number 23 at page 169 of the statement of objections.
169 is it?
Yes.
Yes. Yes, sir.
As your lordship will kindly see, my lord, this is dated 30th of December 2021. And if your lordship will kindly go over to the page at page 170, is the order. And in this, my lord, the order is on the basis of the resolutions passed on 15/12/2017 and 30th of December 2017.
Yes.
Your lordship gets it at page 169. This is the link, the vital link that your lordships have always been asking us. Give me that, what is the link between the petitioner and what you're complaining of? The 2017 resolutions are the link. And but for the 2017 resolutions, this would not have happened. All this would not have happened. And this is a chain of events. Please do not therefore look at it in isolation.
All right. Link in the chain of events.
Yes, my lord, this is a vital link. And these are very important events that have taken place, which has led to the allotment of these sites in favor of the petitioner's wife. That is on 5/1/2022.
Yes.
5/1/2022 is not a standalone document. Now, my lord, please look at page 170 of this document, if I may trouble your lordships, my lord. Page 170, that 50-50 formula has been applied.
Yes, sir.
ಮೈಸೂರು ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಎಕರೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರವು ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಳ್ಳದೆ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಬಾಬ್ತು ಪ್ರಾಧಿಕಾರದ ನಿರ್ಣಯ ದಿನಾಂಕ 20/11. Oh, I'm sorry, my lord, page 169 at 170.
Yes, yes.
ರಂತೆ
You
ಪ್ರಸ್ತಾವ.
can read, sir. I'm all ears. Yes.
I know, my lord, your lordships are not only ears, your lordships also have the mind with me.
Of course, yes. That is yes.
That's more important for us, my lord.
Ears with mind on it. Yes. No, I was just searching for something
No, I'm sorry. I'm sorry.
because
I'm sorry if I
see,
interrupt.
to take it a little further, 14 sale deeds were registered in favor of so and so
Yes.
on 12/1/2022.
Yes,
In terms of that scheme,
yes,
then immediately it is stopped
yes, yes.
on 14/3/23 saying that no
Yes.
allocation of
Yes,
compensatory
yes,
sites
yes.
henceforth.
Yes, yes. Answer is yes. Answer to your lordship question is yes.
All right, yes.
And because on 14/3, my lord, they issued saying stop all further allocation of sites. That is the document, my lord.
Was this the last chunk of allocation, not only to the petitioner's wife, but to others also?
But I'm unable to answer your question this way or that. I don't know.
All right,
I
just,
don't-
they
I,
will answer, I guess.
I don't know whether
No, they-
after 12/1/2022 and especially after the government order dated 14/3/2023, has there been any further
I'm not, after 14/3 Allah.
after 12/1?
Prior to 14/3/23, whether these 14 sites were allotted to the petitioner's wife alone or to several others, one question. The next is after 14/3/2023, was everything stopped?
I'm
Those
given to
are the
understand,
two clarifications.
I'm given to understand, my lord, that after 14/3/2023, everything was stopped.
All right. Yes.
Whether anybody else
After
has been-
14/3/2023?
before,
Before, yes.
that information, my lord, I don't think I'm able to answer your lordship right away
Okay.
because I don't have that information. Now, my lord, now your lordship may kindly see, my lord, on 14/3 when the government says stop it, then kindly see, my lord, on seal number 27. So one other aspect, my lord, which may require your lordship's consideration is what is mentioned at seal number 26.
Yes, sir.
Government of Karnataka cancelled the resolution dated 14/9/2020. We are not able to lay our hands on this resolution. So I am afraid, my lord, I am not able to assist your lordships as to what is the cancellation that was done, which is available at page 281.
So what is that resolution 2020,
I-
14/9/2020?
My lord, I'm not able to help your lordships on that, my lord. That's fine.
All right. Yes.
My lord, what that I'm given to understand. Huh?
Page 282.
No, that is all right. That, my lord, is, if your lordship will kindly see 2710, that may show some light on what is this. Give me that. Huh? This one, page 281. My lord, kindly see page 281, my lord. It seems to throw some light as to what is this.
282.
Yes, correct, my lord, 282. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ
that I've
ದಿನಾಂಕ
seen.
so and so.
282.
ಪರಿಹಾರ ನೀಡದೆ ಜಮೀನನ್ನು ಉಪಯೋಗಿಸಿದ
50/50 scheme was withdrawn.
ಸ್ಕೀಮ್ ಅನ್ನು has been withdrawn. ರದ್ದುಪಡಿಸಲಾಗಿದೆ.
Cancelled. Withdrawn.
So, and then, my lord, there is so much of maladministration in Muda that the government, my lord, had appointed a committee and kindly see, my lord, serial number 27,
For what purpose?
to inquire generally into what all is happening in Muda.
That is nothing,
I-
there's no bearing on this.
I also see that, my lord, because there is no specific point on which they were asked. But the fact appears to be that
General maladministration.
that is a general, I agree. And then, my lord, there is a show cause notice issued. Now, my lord, seal number 28. A show cause notice issued to the deputy commissioner calling upon Muda to answer the allegations made which your lordships will find, my lord, at page 292.
Yes.
Two 92, my lord, there are, again, my lord, if your lordships ask me a question as to whether this has anything specific in relation to the allotment made in favor of the petitioner's wife, the answer to that question is no. There is nothing specific.
No, that has nothing to do. Yeah, general maladministration.
General maladministration.
That is in public domain.
Yes, my lord.
Yes.
Maladministration is in public domain.
No, true. That's yeah, public domain. That maladministration is more in Muda. That's a different thing. Yes.
And then, my lord, your lordship may kindly turn to 29. 9/11/2023, Deputy Commissioner called upon Muda to stop all allotment of sites. And then, my lord, allegation, etc. And then, my lord, 3/7/2024, there was a complaint filed by respondent number 4 before the jurisdictional police, which if you brought your lordship's notice, my lord, the magistrate said, how can I proceed afterwards?
No, that's not that.
This is the complaint filed with the police.
Explained before jurisdictional.
Yes,
police.
correct. Yes, correct.
Then
No,
local.
then, my lord, we have another, that we have, my lord,
First jurisdictional police,
court.
then local,
and
then
my lord,
private
seal
company.
number 36.
Yes,
Seal number 36.
that's what Rangnath Reddy told.
Yes, yes.
They've
correct.
complied with all
Yes,
154,
yes,
1,
all
3,
that has been
and
done.
then
All,
200.
all that has been done, my lord, we have set it out. And we also filed a complaint under 200 before the magistrate. Of course, my lord, it was reserved for orders on the question. Special court, I'm sorry, on the question as to whether the governor's sanction was required even to proceed further. It was posted for orders on that question.
It was
When your
reserved.
lordships,
It was reserved for orders. Now it
It
is
was-
preserved for orders.
it is preserved for orders.
Because of these.
Yeah, your lordship's protection.
Yes.
So, my lord, what was reserved for orders was
Is now
preserved for your
preserved.
lordship's protection.
Yes.
That is how it is.
Document for Taripura, page 320. Go to the police station.
Yeah, that's okay, that's okay, that's okay. Now, my lord, let me go to the order passed by the government at page number 42. Kindly see the order. Now that your lordships have got, these are the factual aspects which I wanted to highlight for your lordships, from which my respectful submission to your lordship is that the connection between the petitioner and the actions which were taken in 2017, which culminated ultimately, my lord, in the execution of the sale deeds in 2022, is quite clear and undisputable. Therefore, my lord, it is not, the question I would pose for myself is whether in 2022, the petitioners had any role. That's not the correct question. It might respect to submission. The correct question is in 2017, did the petitioner have a role to play? Undisputedly, yes. And I think, my lord, he was also the district minister. He was also the district in charge.
He was chief minister, sir.
Yes, no, he was deputy chief minister.
Yavaga?
2017.
17.
17
Chief.
17, he was chief minister.
Yes. Where
Yeah.
is district in charge?
No, I'm sorry. When 2004, he was district in charge. 2017, he was the chief minister. He was chief minister for 5 years, full term.
All right. Yes.
Yes. No, my lord, that's right. Now, my lord, please look at page 42. The petition, my lord, I want to draw your lordship's consideration.
Governor's order.
Governor's order.
Hmm.
Now, my lord, what was told to your lordship was that there is non-application of mind by the government with respect to the question as to whether there is a case for inquiry or not.
That the learned solicitor general is elaborately.
Yes, I want to point out one thing to your lordships in that. If it has already been pointed out, then, my lord, I apologize for the repetition.
No, I don't
But
know. what-
unless I tell your lordships what I am saying,
know
you
what
can't
you're
say
pointing
everybody. Exactly, my lord. Therefore, that is the reason. I know, my lord, it is a difficult question. Unless I say,
Yes.
you will not be able to say it's already been said. So let me say what I want to say.
So after it is said, I will.
No, of course, your lord. Lord, I recognize, my lord, the court's authority, and the court should stop a counsel if there is repetition. Of course, my lord. Otherwise, this will go. This will be ad nauseum. My lord, kindly now see, my lord, the paragraph number 4 at page 43. It is seen from the decision taken by the Council of Ministers that a committee under the chairmanship of Sri Venkatachalapati IAS was constituted to look into the present matter. However, the government, upon considering the facts of the present matter, as reported in the media newspapers, appointed a high-level single-member inquiry committee under the Commission of Inquiries Act. It appears from the terms of reference of the high-level single-member inquiry committee that there are serious allegations involving illegal allotment of alternative sites, illegal allotment of land, and irregularities in allocation of land. Further, the constituting of a committee under the IAS officer and immediately constituting one more committee under a retired judge of the High Court, and the government's own acceptance that there is a potential big ticket scam in the allotment of sites by Muda does not inspire much confidence. It is well settled legal principle that persons against whom allegations are made should not be empowered to decide the course of action, even after such grave allegations being involved in the present case. And the fact that the materials prima facie supports the allegation, therefore, decision taken by the council of it is irrational. That is, my lord.
Now I can say it is already said.
Yes. Now, my lord, please look at paragraph number 6. I have considered the decision of the cabinet dated 1/8/2024. I'm going to skip that because it's already been said.
Yes.
Madhya Pradesh, etc., already been
Ella.
said. So I'm going to skip that. Now, my lord, please be kind enough to turn to paragraph number 10. That, my lord, is the point that I want to emphasize for your lordship's consideration. Upon perusal of the petition, along with the materials in support of the allegations in the petition, and subsequent reply of Sri Siddaramaiah and the advice of the state cabinet along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. Therefore, my lord, I pause for a moment here to say the governor, my lord, has said, look, there is one thing that is being said by one set of people. There is another thing that has been said by another. Here is the cabinet which says nothing is wrong. Here is somebody else who says something is wrong. There are two versions. Therefore, I will get it inquired into. And it is very necessary that a neutral, objective, and non-partisan investigation should be conducted. I am prima facie satisfied that the allegations and the supporting materials disclose commission of the offense. So therefore, my lord, this much of application of mine, in my respectful submission, is more than ample. Anything more, there would have been, my lord, an allegation that the
You're
government
reading
has...
the order.
My lord?
You're reading the order.
Yes.
The learned Solicitor General has produced the entire file.
No, my lord. I know, I'm aware of that.
So there is more than
More
what is
than
there.
that. I'm not going into that, my lord. Your lordships are going to look at it. My learned friends
No,
are going to...
the submission of not even a semblance traveled to abundance after the original file was placed.
Yeah, absolutely. Absolutely. And I would say, my lord, the original file discloses much more than what the order discloses. Even on the order, it cannot be said that there is non-application of mine. In fact, if anything more had been said in the order, my lord. Now, my lord, lot of material is there available in the file. Whatever is available, my lord, your lordships are
We'll
going to look at it.
consider, yes.
I'm not going to comment on that. Now, take the order on the face of it.
It does bear application of
It
mine.
does bear application of mine because if anything more had been said in the order, allegation would have been that you have made up your mind on one way or the other.
He is not,
No, no.
no authority to make up the mind.
Allegation. I'm underlying the word allegation. Is that you would have done it. My lord, you do, you are damned. You don't, you are damned. My lord, this is a very thin line to be drawn. Where is consideration? Where is non-consideration? Now, my lord, this is what I wanted to point out. Now, my lord, what was told to your lordship was, how is it that the petition that has been filed, my lord, we produced for your lordship's consideration the petition that we had filed with the governor of 31/7/2024.
Yes, you told. A
I produced-
memo
Yes,
jate kotte.
exactly. And I'm sure, my lord, your lordships will look at the records to find out as to whether it is there or not, because insinuations were made.
Which file? Which file it is not there? You've seen. All right.
Is it there or not?
I will also see.
The reference to it, it means the reference to it, we also not.
We have no, I have had no access, but
Yes, yes.
anyway, your lordship will look at it, my lord, whether what I say or what
The
he says.
file is given to me. Will-
Your lordship look at it, my lord. Now, my lord, the allegations in the 31/7/2024 communication is identical to the allegation that have been made in the complaint of Mr. T.J. Abraham. Now, my lord, in a situation of this kind, what was told to your lordship was, I was given a copy only of T.J. Abraham's petition. I was never given a copy of the petition filed by respondent number 4, and therefore the order is vitiated. My lord, and it was made to appear that as if permission is granted to the respondents by this order. Kindly see, my lord, what para 11 says. I think it's a complete misreading of the order of the Honorable Governor by the other side.
Clarified.
My lord, I'll clarify it, my lord.
That is clarified.
I didn't follow.
That is clarified by the Solicitor General.
Very well. If it is being done with it is not a question of anybody being given permission to do anything. It is lifting of a bar. Now, my lord, in this context, if I am right in my submission with respect to paragraph number 11, which has been clarified to your lordships. Now, my lord, there's one submission that I want to make. My lord, your lordship may kindly look at one judgment of the Honorable Supreme Court, my lord. There are three distinct concepts. One is a direction, the other is sanction, the third is approval. This is the pyramid. In respect of each of these actions, the standard required is different. Now, my lord, that has been laid down by the Honorable Supreme Court, my lord. In 1952 to SCC 203. 1952, Volume 2, SCC 203. Give it to me. One ನಿಮಿಷ.
SCR.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲ. ಇಲ್ಲಿ kindly turn to page 760.
Now they have done it.
ಮಾಡಿದ್ದಾರೆ ಅದೇ.
ಈಗ ಮಾಡಿದ್ರು.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
Right from 50 it is.
ಮಾಡಿದ್ದಾರೆ. ಈಗ ಮಾಡಿದ್ದಾರೆ ಸರ್.
Earlier from 50 to 69 it was SCR. Now it is.
ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. Kindly turn to page 762. In volume 2. Huh? Well, kindly turn to paragraph number 11 and para 12. My lord, we are not, in the instant case, my lord, we are not concerned with either direction or sanction. We are only concerned with approval.
Yes.
My lord, kindly see para 11. In both the cases of sanction and direction, an application of mind is necessary. But there is an essential difference that in the one case, there is a legal impediment to the prosecution if there be no sanction. And in the other case, there is a positive order that the prosecution should be launched. For a sanction, all that is necessary for the one to be satisfied about is the existence of a prima facie case. In the case of direction, a further element that the accused deserves to be prosecuted is involved. Therefore, my lord, direction is at a higher pedestal. Then your lordships have sanction, and then your lordships have the concept of approval.
Last 4 lines of that paragraph.
Yes, my lord. Whether sanction should be granted or not may conceivably depend upon consideration extraneous to the merits of the case. But where the prosecution is directed, it means that the authority who gives the direction is satisfied in his own mind that the case must be initiated. Sanction is in the nature of a permission, while a direction is in the nature of a command.
So
Now,
this
my lord, where does this come? This is neither a sanction, neither a direction, it is an approval.
Because
It is at the bottom of the pyramid. So therefore, if direction requires something more, it requires the highest element of application of mind, and then your lordships have the sanction and then approval. So, my lord, if we look at it that way, then, my lord, the standard required for the purpose of 17A is much less in rigor than for a sanction under 19. Now, my lord, please see para 12. Let us now examine some of the decisions on the subject. For the appellant, strong reliance was placed on the judgment of the Privy Council in so and so, and it was argued that on the basis of some of the observations of the Judicial Committee that a sanction was an important and substantial matter and not a mere formality. The facts in that case were that while there was a sanction of the government for prosecution under the Cotton, Cloth and Yarn Control Order, there was nothing in the sanction itself or in the shape of extraneous evidence to show that sanction was accorded after the relevant facts were placed before the sanctioning authority. To quote the lordship's own words, there is no evidence to show that the report of the sub-inspector, the district superintendent of police, etc., I'm going to skip that. Prosecution was in a position either to produce or to account for the absence of the report made to the district superintendent of police and the endorsement of the district magistrate referred to in the sanction. It is in this connection that their lordships emphasize that sanction to prosecute is an important step constituting a condition precedent and observe, looked at as a matter of substance, it is plain that the government cannot adequately discharge the obligation of deciding whether to give or withhold a sanction without a knowledge of the facts of the case. Nor, in the lordship's view, is a sanction given without reference to the facts constituting the offence a compliance with the actual terms of clause 23. This, however, is no authority for the position that a sanction stands on the same footing as a direction. Therefore, sanction is different from direction. It is true that the facts should be known to the sanctioning authority, but it is not at all necessary that the authority should embark also on an investigation of the facts, deep or perfunctory, before according sanction. Your lordship may mark that, Manoj. Even a deep or a perfunctory, he need not do it. The decision lends no support to the view that wherever there is a sanction, the sanctioning authority is disabled under section 556 of the code from trying the case initiated as a result of the sanction. On the other hand, there is plenty of support for the opposite view.
Yes.
Now, my lord, having shown to your lordship this, may I now request your lordship to take my compilation of judgments, my lord. I'm not going to show to your lordships, take your lordship through all this, because in our submission that we have made, we have extracted the relevant paragraphs, my lord. Though I must tell your lordships, my lord, that it appears, my lord, that the government in England appointed a commission to go into the merits and demerits of oral arguments in courts and written argument that is prevails, my lord, in the United States. And the report of the commission was a meaningful shrug of the shoulders of a Queen's Counsel is worth 100 pages of written arguments.
Yes, sir.
But I know, my lord, but
All right. Yes.
I'll leave it. I have given your lordships the extracts of the paragraphs, which, my lord, will not have
We'll harmonize the two.
harmonize the two, and your lordships may read that, my lord. But having said that, I want to point out to your lordships one thing. Now, my lord, kindly look at the scope of 17A, which your lordships have looked at in several cases.
Mm.
Lord, your lordships have seen Ashok's case, which is your lordship's judgment. I'm not going to detain your lordships on that. But then, my lord, before the judgment in Ashok came, there was another judgment of your lordships in Sri Rupa,
Yes.
which, my lord, your lordship will find is at page 496,
Mm.
which is in volume 2.
Mm.
Please look at it for a minute. I'm just going to show to your lordships for a different purpose. I know, my lord, your lordships have authored the judgment.
Yes.
Kindly see paragraph number 11. What was it? What was the aspect which prevailed upon this honorable court to hold, my lord, that the sanction was not, that the sanction was not enough?
Approval.
No, it just said ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ ಅಷ್ಟೇ.
ಅದಕ್ಕೋಸ್ಕರ ಬರೆದಿದ್ದು.
ಅದಕ್ಕೋಸ್ಕರ, exactly. Now, this aspect of the matter, I only wanted to point out, your lordship, that particular fact which your lordships have not seen. This aspect of the matter, my lord, was looked at again by another coordinate bench of this court.
Yes, when it came again,
Yes.
there it is held that it stands on a different footing.
Yes.
Because it was 19 then.
No.
It is not 19,
No,
is it?
ಅದು 17 ಏನೆ.
ಮತ್ತೆ?
ಹೌದು. ಇಲ್ಲ, ತಾವು ಕಳ್ಸಿದ ಮೇಲೆ ತಿರ್ಗಾ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಓ, ತಿರ್ಗಾ
Your lordship may look at that, my lord, which is at page 510.
Volume.
My lord, that is the judgment of his lordship Justice Sanjay Gowda.
Yes.
Please be kind enough to turn, my lord. There your lordship may kindly see, my lord, how it has been distinguished. And that is why, my lord, my respectful submission to your lordship will be, do not apply the approach that your lordships adopted in Ashok's case. My lord, please be kind enough to turn.
Para 29 to
My
31.
lord, please see para 33, my lord. I want
33
your
is the
lordship to kindly
finding,
see. 33.
but 31 is what is said.
My lord, what is relevant to not actually is para 39 to 49.
All right.
But please see para 33 for a minute
Yes, sir.
at page 516. Section 17A of the Act is drafted with the overarching objective of ensuring that unnecessary investigations against public servants are prevented, and the state government is required to take a decision to accord or refuse approval to conduct an investigation within a time frame. This indicates the balance that the law intended to strike in the manner of an investigation being conducted against a public servant. Now, my lord, please be kind enough to turn to paragraph number 36. I'm going to skip 34 and 35. At this stage, the stark and striking difference.
No, there it was again elaborate. That's why 49, my order is quoted. 51, it is said it bears application of mine, dismissed.
In fact, your lordship's order is quoted, and my lord, the learned judge holds because of that Kulankushavagi Parishadalagide was the only ground. But then, my lord, the law is explained further. Now, my lord, just look at para 40. I'm going to skip a few paragraphs, my lord, though I thought it's relevant, but summary is there. To summarize, the law has conferred a twofold protection vis-a-vis a public servant for offences under the Act. The first layer of protection is even before an investigation is conducted, where a prior approval is needed under Section 17A of the Act. The second layer of protection is after completion of investigation, where sanction to prosecute the public servant is required under Section 19. It is clear from the statutory framework the legislature has decided to not only protect public servants from unwanted investigation, but also from a prosecution by making it mandatory for the investigating officer to obtain two different and separate approvals for investigation and for prosecution. It should also not be forgotten that merely because an approval is accorded to conduct an investigation, investigating officer cannot proceed to prosecute the public servant, and he is still required to obtain prior sanction of the government to prosecute the public servant under Section 19. Then, my lord, your lordship may kindly turn to paragraph number 47.
Caesar's wife
My lord,
must be above suspicion.
yes. And now, my lord, no, my lord, after those few lines, the integrity of a public servant is required to be beyond suspicion, as in the proverbial adage, the Caesar's wife must be above suspicion. If there exists even a shadow of doubt on the integrity of the public servant, it will not only harm his reputation, but will also tarnish the entire system of which he is a part. Thus, in such a situation, if the aspersions cast on the integrity of a public servant and an investigating officer under the Act harbors a view that an investigation is necessary, it would be in the interest of both the government and the public servant that such a nagging suspicion is obliterated. So, my lord, the word emphasizes nagging suspicion. Is it there or not in this case? That's all the inquiry. Some element of discomfort is enough. Unless you're not with that, nothing. I'm so comfortable with what's happened.
Lurking suspicion.
Lurking suspicion is a nagging suspicion.
Nagging.
Anyway, my lord, that's the wording that his lordship has used now. In order to achieve this objective, therefore, the government should be given the greatest degree of latitude to accord approval for conducting investigation. So this is the approach, my lord. This is what I mentioned to your lordship at the beginning of my submission. Approach must be, if there is some suspicion, allow the investigation to take place. Do not scuttle it at the very start. Then, my lord, the contention, therefore, that the material furnished by the investigating officer is required to be subjected to a microscopic examination before according approval to investigate a public servant, as suggested by learned senior counsel appearing for the petitioner, does not merit acceptance. As stated earlier, before seeking approval under 17A of the Act, the investigating officer would only have to form a tentative opinion to determine as to whether an investigation is warranted or not, having regard to the material credible information in his possession at that point of time. It may so happen that after conducting an investigation, investigating officer may very well come to the conclusion that there is no justification for initiating prosecution and may drop such proceeding against the public servant. Thus, the mere grant of approval to conduct investigation would not lead to an inference that the investigation would necessarily culminate in a prosecution against the public servant. And then, my lord, the judgment of this honorable court in Ashok's case is cited. And this earlier Sri Rupa's case. The argument that the materials collected have to be considered meticulously, as indicated by this court in WP number so and so, cannot be accepted for the reason that in the said writ petition, the court was considering an order of approval in that case, where the order of approval merely stated that the government had meticulously considered the matter by use of the term Kulankashavagi Parishadalagi. The relevant portion of the order reads as follows, my lord. Then, my lord, para 52. In my view, this indicates that the state has applied its mind to the request made by the investigating officer and has considered the matter rationally before according its approval to investigate the petitioner and another. In the light of the distinguishing feature, the decision relied upon the learned counsel for the petitioner in WP number so and so in support that cannot be of any.
So let governor has applied his mind. in
My
this.
lord?
You want to,
Yes.
you
this
want
is
to
the-
paraphrase that, yes.
Yes, my lord. This is-
Governor has applied
Yes,
his mind.
correct. Yeah, absolutely, my lord. That's and I want to show to your lord. I wanted to show to your lordship, which I believe I have done, to say what was the basis on which your lordship's judgment in that
No,
case
that's
was
still
based.
I am aware.
That's
yes.
all. That's all. And I wanted to show to your lordship that this is and there's another view that has been taken by this honorable court and other coordinate bench. Your lordship may kindly see, my lord, though it arises under 156(3), please see, my lord, page 522. Kindly turn to paragraph number 48 at 536.
Yes, this I have.
Your lordship. But these judgments support the proposition that I am placing for your lordship's consideration, that it should be looked at in a very broad manner, especially having regard to those words relatable to and not commission of or recommendation by. Those words are not there. It is relatable to. In the context of a contractual clause, the Honorable Supreme Court has held, my lord, that these words relating to, in regard to, in relation to, are words of widest amplitude. ಇದೆಯಾ? General Electric. Renu sir. Though, my lord, it arose in the context of the interpretation of a contractual clause, I would say, my lord, the same principle applies when your lordships are interpreting this. My lord, please be kind enough to turn to paragraph 25 of the judgment of the Honorable Supreme Court, my lord, in Renu Sagar.
You want term relatable?
Yes. What is the meaning of these words relatable? How do you understand it? What is so special in law when you use this word relatable?
Paragraph.
My lord, paragraph 25.
It's not part of compilation.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ copy?
Yes.
Four propositions emerge very clearly from the authorities discussed above. One, whether a given dispute inclusive of the arbitrator's jurisdiction within the scope of the purview of an arbitration clause or not primarily depends upon the terms of the clause itself is a question of what the parties intend to provide and what language they employ. Two, expressions such as arising out of, or in respect of, or in connection with, or in relation to, or in consequence of, or concerning, or relating to the contract are of widest amplitude and content and include even questions as to the existence, validity, and scope of the arbitration agreement. Now, my lord, I'm only the first portion of it. It is of widest amplitude. Otherwise, my lord, I ask myself the question, why did the legislature use the word relatable to? They could simply have used, without that word, the section could have made sense. It is, did you play a role in relation to that recommendation or decision? Is a question. And the role could be minuscule. Even then, the act applies.
Needle of suspicion.
Needle of suspicion. Needle of suspicion, my lord, is the crux of the matter, is what I would submit your lordship for consideration. Now, my lord, another aspect, my lord, I want to take your lordship through the index, my lord, so your lordships get an idea as to what is this, what is it that we are, and if there is any particular aspect on which, my lord, I think is necessary, and if your lordship permit me for me to dilate, I will do it.
163, the Solicitor General has relied on, same judgments.
My lord, yes, and I want to point out only one thing, my lord. In what was told to your lordship by the petitioner was that the law laid down in MP Special Police Establishment case has been watered down.
No, that is clarified.
So therefore, I will not, very well. But that's why, my lord,
Nawab Rabia went on a different footing.
no, in fact, Nawab Arabia says that's it, affirms it. On the contrary, my lord, without diluting, what was told to your lordships by the petitioners was that the judgment of the Supreme Court in Nawab Arabia has diluted the law laid down in MP.
No, that submission was diluted.
I will not object.
Yes.
Now, my lord, your lordships may kindly look at, there is one judgment, my lord, which possibly will have a bearing to a certain extent at the present stage
On what?
on discretionary powers of the government. And then your lordship gets Antule's case, my lord. Antule's case, my lord, seems to suggest that the power of the court under 156(3) is not trampled by 17A. Though 17A was not there at
17
that
was
time.
not there.
I think that, and I am
5A of the old act.
the old provision, my lord, they were considering that. 17A was not there. 17A
No,
was there.
17 is 2018. What was considered was not even section 19.
No.
It was under the old
Old
act.
Act, 5A.
What was sanctioned in,
5A.
that is Abdul Rahman and
5A,
case.
5A.
Yes.
So even there, the question, my lord, is as to whether the power of the court under 156(3) is circumscribed by the requirement of a permission. And the view, as I understand in Antule's case, my lord, is that the power of the court is not taken away. And I'm given to understand, my lord, that matter, that question is pending before a larger bench. In any event, my lord, that may be a little premature to be discussed in this proceeding today, because we are looking at, now, my lord, your lordship may kindly look at what we have now placed for your lordship consideration, my lord, is section 17A has been considered, my lord, in Yashwant Sinha's case.
That's the beginning.
That's the beginning.
The first judgment on 17.
Exactly. We have put all that, my lord, so that it's all in one place. And then, my lord, there is another submission that I want to make. Yeah, yeah. My lord, there are two situations. One is absence of sanction. The other, my lord, is invalidity of sanction. Now, can the question of invalidity of sanction be taken up before the special court?
See, that is one point where sanction is accorded, invalidity of sanction or otherwise in normal circumstances. Now the issue is sanction is accorded by a constitutional authority. That cannot be taken there. Therefore, the validity of that sanction, whether it bears application of mind, it is needed or otherwise, is only by this court. That
But-
cannot, the Court of Session cannot sit and scrutinize what the governor has said, whether he has applied his mind, he has done that, he has done this. No. This court is.
My lord, that distinction that your lordships are putting to me between a sanction that is accorded by
You began the submission saying that this is governor's sanction, high functionary's sanction. It is not like a tahsildar issuing
Yes.
sanction. The same thing applies here also.
Now, that submission was made, but not in the context of the fact as to what is the extent of judicial
Examination.
examination.
See, that is why
That purpose.
the extent of examination, if that is so, that we are not examining the order of a tahsildar, but we are examining the order of the governor of the state sanctioning or approving whatever is to be done against the chief minister of the state, then it's not that the court will scrutinize whether governor has applied his mind or not. It's constitutional court will do it.
I'm not saying the constitutional court cannot. I'm
There is nothing that-
saying, is it?
There's
a
nothing
case?
that this court cannot.
Exactly.
Yes.
There's nothing that this court cannot. In
See,
fact,
anything this before this court is maintainable, whether
Exactly.
it is entertainable or
that is
not,
the
it
point, my lord.
distinguished.
That is exactly what the Honorable Supreme Court also has said, my lord, the recent judgment in
Yes.
Godrej Sarali.
Yes.
Supreme Court has said, the question when a writ petition is filed is not as to whether writ is maintainable. The
Every
question
petition is maintainable,
every
whether it is entertainable or not,
Exactly, my lord.
it is the discretion of the
Exactly.
court.
Now, in a situation of this kind, now just look at what the Honorable Supreme Court has said, my lord, in 2020. Please be kind enough to turn to page 607.
No, it can be decided during the course of trial is what is
Exactly.
said.
Yes. Now, if
One
you
minute, validity in that judgment was qua the competent authority. Whether the competent authority had accorded sanction or not, that can be decided there, no problem. Here, that is not the question of competent authority here. Here it is the question of sanction being accorded by the governor to granting approval. Even sanction is said in that, so I can say granting sanction for prosecuting the chief minister. That cannot be. That I don't agree.
but the proposition seems to be a little wider than what your lordships have put to me. That it is only the power or who is the sanctioning authority which can be gone into at the time of trial and not otherwise. But not the
No,
proposition seems-
validity, qua the competence. See, now it is the managing director of a particular organization who is the competent authority declared to grant sanction. Somebody else has granted. That can be debated before the concerned court at the time of trial at any stage of the trial. That's a different thing. Whether here application of mind is there for the purpose of grant of sanction or otherwise, qua these people, yes, is tribal here. And merely because it is to be considered during the trial, it would not lock the hands of this court to consider it.
My lord, I don't think I'm going to canvass that proposition at all. 226 jurisdiction, my lord, is unlimited. It is only self-regulatory, self-discipline, etc., etc.
So we'll
there-
do that.
But in the facts of a given case where
I will answer that because that is also submitted.
Okay.
I will answer that.
But that, yeah, just for reference, my lord, we are given the judgment of His Lordship Justice Bopanna as it then was at page 607.
Yes.
I'm not sure whether this was showed to your lordships.
No, with Justice Bopanna or the
Yes.
page.
My lord, page 607. my lord, the relevant portion is at page 613. My lord, may I trouble your lordships to kindly see the facts at para number 2. It seems to lay down a slightly broader proposition than what your lordships put to me.
Yes.
My lord, please now be kind enough to turn
Para 11.
paragraph number 11.
Yes.
Yes. Further, the issue relating to the validity of the sanction for prosecution would have been considered only during trial, since essentially the conclusion reached by the High Court is with regard to the defective sanction, since according to the High Court, the procedure of providing opportunity for explanation
Yes.
was not followed,
Those things
which will
can.
result in the sanction being defective.
No problem.
Next sentence, my lord. In that regard, the decision in Dinesh Kumar relied upon by the additional Solicitor General would be relevant, since it is held therein that there is a distinction between absence of sanction and the alleged invalidity on account of non-application of mind.
Hmm.
The absence of sanction no doubt can be agitated at the threshold, but the invalidity of sanction is to be raised during the trial. In the instant case, admittedly there is sanction, though the accused seek to pick holes in the manner the sanction has been granted and to claim that the same is defective, which is a matter to be considered in the trial. So, my lord, on this,
We have not yet reached sanction. We are at approval threshold.
yes, my lord, but it doesn't really bear any difference.
Difference. No, no, no.
It doesn't
See,
bear any
sanction is post investigation.
Yes, it is different stages.
No, the
It is
sanction
different
is
stages.
post, between 17 and 19, what happens is investigation.
Absolutely.
Abundant material to seek sanction to prosecute.
Absolutely.
Now, there is prima facie material, needle of suspicion in 17A.
Yes, needless suspicion. I'm only saying, my lord, only for this purpose. If you can raise the correctness of a sanction under 19, even 17A is a matter that can be raised there. So, my lord, I would say, my lord, that this principle should be extended there also. That's a submission I'm making, my lord, because I believe, my lord, Dinesh Kumar also says the same thing. And
Yes.
then, my lord, your lordship may kindly look at the next proposition.
Yes.
Sanction is an administrative order, my lord.
That
I
is-
think it's
that
already
is-
been, we have, my lord, I'm conscious that it has been told to your lordships. We are just giving your lordships all the material in order
And
to
these judgments are also
assist,
given.
in order to assist your
Yes,
lordships in
yes.
writing the judgment, my lord. That's all. Then, my lord, Commission of Inquiry, what is the scope? It's just a report, and my lord, the Supreme Court.
No, it
says
is only recommended.
the Supreme Court says it is unfortunate that most of the reports don't see the light of day.
Anyway, but it's recommendatory.
Yes, my lord, absolutely. And then, my lord, kindly turn to the next one. Next page. Complaint need not be a detailed complaint. My lord, your lordships are aware of that proposition. It need not be an encyclopedia. But what am I going to say as a complainant? I don't have all the material.
No, no, in fact, in this case, it is detailed.
In this case, we have written 5-6 pages, my lord, and single line spacing.
Single line spacing. Adnan Nodlilva. I did not look into that, yes.
Illa, the complaint is in single line spacing.
All right.
So much of material has been, so many
No,
facts.
it
have
is
been
in detail.
It is in detail. Therefore, my lord, we have given your lordship the 3 number 30 and
It is in
31.
detail. The complainant has appeared before the governor. The governor has heard him.
Not as my lord,
R3.
our,
R3.
yes. And then, my lord, on this question of natural justice, I just want to point out, your lordships, how natural justice, my lord, is not some straitjacket formula. Kindly see, my lord, serial number 26. Ashok Kumar Sonkar's case.
All of them follow unruly horse.
Yeah, unruly.
1976.